Hello, my name is Harold Eaton, and I'm a justice on the Vermont Supreme Court. I'm with you today for what is called a jury orientation, the purpose of which is to give you information about the jury selection process and about your service as a juror. Before we get into the specifics, I'd like to spend a few minutes discussing jury service in general. Let me start by thanking you in advance for the important role you are about to play in our system of justice. I'm sure that many, if not most of you, were not thrilled to get your jury summons. Many people start out viewing jury service as an imposition. After all, we have busy lives, and who has time for jury service now? I understand if you feel that way, but I'd like to share a few thoughts with you that I hope may give you a different perspective. The ability to have a trial by jury of one's peers is the bedrock of our democracy. It is a large part of what makes our country different from so many others around the world. There are millions of people who do not have such a right and wish that they did. The founders of this country anticipated that jury service might be a hardship, but felt that having a jury of one's peers was a vital component of the justice system. They did not want juries to be made up only of people who had nothing better to do. The importance of having a cross-section of society is why we do not let people volunteer to be on juries. The random selection process that each of you went through helps to ensure a jury of one's peers. As many of you know, initially in this country, juries were comprised only of white men. After the Civil War, all male citizens were permitted to serve, but women were excluded from juries for much longer, finally being allowed to serve in Vermont beginning in 1943. There was a time, not so long ago, when people had to struggle to get the opportunity for jury service. I believe the imposition posed by jury service is less today than it used to be. I expect that many, if not most of you, drove here today. Again, it was not that long ago people answering a jury summons would have to come from across the county by horseback or similar means to get to the courthouse, which could take hours. A comparatively quick car ride was not available. Even when I started practicing law, juries in serious cases were routinely sequestered. At the end of the day, if the trial wasn't over, the jurors were loaded onto a bus and taken to a hotel for the night. If the trial wasn't finished on Friday, they spent the weekend at a hotel. Today, a sequestered jury is a rarity. Before going on the Supreme Court, I spent 10 years as a trial judge. In Vermont, the trial judges do not stay in one court all the time. They rotate after a year or two to a different court. But there are things that as a trial judge you remember along the way and take with you. I want to share two of my memories of jury service with you. When doing jury orientation in person, I would start out by asking if there was anyone who really wanted to be there. Usually I would get no or very few responses. One time, however, a woman waved her hand quite noticeably to my question. She was so adamant I thought she must have misunderstood. So I asked her directly if she really wanted to be there for jury service. "Yes," she said, "I have only been an American citizen for a few months, and getting to serve on a jury is the biggest honor of my life." Another time, I had noticed a young man in his early 20s sitting in the front row of prospective jurors while I did my orientation. He looked a bit disheveled and disinterested, and I figured he wanted out as fast as he could get there. At the end of my remarks, I asked if there were any questions. His hand shot up, so I called on him. "Am I going to have to come back again?" he asked. Because the clerk had already told that panel of prospective jurors they would have to come back twice more, I thought his question confirmed my suspicions of his disinterest. But I couldn't resist asking why he wanted to know yet again. "Because I had to walk here today," he answered. It turned out that he had walked from Randolph to Chelsea, about 15 miles, to do his jury service. That sacrifice on his part explained his slightly disheveled appearance, and it reminded me that you should never judge a book by its cover. Your jury service is important to the parties, to the people of Vermont, and to our democracy. The judge and the court staff will do everything they can to make your time as a juror go as smoothly as possible. Before getting into the orientation itself, some of you may have wondered why judges wear black robes. There is no rule or statute in Vermont that requires judges to wear robes at all, or if so, to wear black ones. But in Vermont and across the country, almost all judges do. The reason why is uncertain, but there are several possible answers. I have been told that wearing black makes you look thinner, but I refuse to believe that is the real reason we wear them. Others think that black is a color of neutrality befitting a judge. Still others think that all judges wearing black is a sign of their unity of purpose in the application of the law. It is also suggested the tradition was started by John Marshall, who wore a black robe at his investiture as Chief Justice in 1804. But my two favorite answers are more historical. Some say that when the U.S. gained independence from England, an argument ensued between John Adams, a lawyer, and his rival Thomas Jefferson, a non-lawyer, about how judges should be attired while on the bench. Adams wanted judges to wear robes and wigs, as in England, and Jefferson wanted them to wear regular business attire. The story goes that they reached a political compromise, which was to have judges keep the robes and not wear wigs. But that still doesn't answer the color question, which points me to another answer. In England, in the 1600s, judges wore robes of many colors. During the late 1600s, under the reign of William and Mary, the English Bill of Rights was adopted, which gave judges a great deal of judicial independence. That is, the freedom to decide cases without interference from the monarchy. When Queen Mary died in 1694, the judges attending her funeral wore black robes as a sign of mourning over her death. Therefore, some people believe judges wear black robes today because we continue to mourn the death of Queen Mary in 1694. Now I want to discuss some specifics of your jury service. First, how did your name come to be selected for jury service? In Vermont, our initial pool of jurors is comprised of those who are registered to vote and those who are licensed to drive. From that list, the pool is narrowed down by random selection, and those potential jurors still in the pool receive juror questionnaires asking basic questions, including whether there is any reason you cannot serve as a juror, and if so, why. Some people are then excused based upon their answers. My favorite questionnaire reply was the one where the person said they couldn't serve as a juror because they had a severe, or maybe profound, they couldn't decide which, inability to make decisions. Those whose names remain in the pool after the questionnaires have been reviewed are directed to appear as you have been. What is your role as jurors? The purpose of a jury is to find the facts by listening to and weighing the evidence. You are the only finders of fact, and your job is very important. In a criminal trial, you're not required to find every fact. Rather, you are to find the facts concerning the essential elements of the charges being tried. In his or her instructions to you, the judge will tell you what those essential elements are. By way of example only, in a driving under the influence charge, whether the defendant was driving a motor vehicle is an essential element. The color of the motor vehicle would not be. Because it is not possible in a trial for you to hear all the evidence at once, jurors must keep an open mind until all the evidence has been presented, closing arguments have been made, the judge has instructed the jury on the law applicable to the case, and you have retired to deliberate. Only then may jurors begin to discuss and decide the case. The jury trial is not the first event to take place in a criminal case. The case began with an arraignment based upon charges brought by the state. After arraignment, there may or may not have been motions filed and decided on various points of law. After that, the case is scheduled for jury selection with a trial to follow at some time thereafter. During the jury selection process, you will be told when the trial has been scheduled so that you may raise any scheduling concerns with the judge. There are several important things you must remember in carrying out your duties as jurors. First, the fact that the defendant has been charged with one or more crimes is not evidence of his or her guilt. You are not to give any weight to the fact a defendant has been charged with one or more crimes. Your job is to fairly and impartially decide the case based only upon the facts as you find them and the law as given to you by the judge in his or her instructions. In a criminal trial, the burden of proof is on the state. That burden is to prove the essential elements of the charges beyond a reasonable doubt, which the judge will explain to you in his or her instructions to you during the trial. There are some very limited situations where a defendant has the burden of proof on some defenses, and if you are involved in such a case, the judge will explain that to you. Under our system of justice, every defendant is presumed innocent of all charges unless and until you find him or her guilty. As every trial starts, the defendant is innocent of all charges. The presumption of innocence is itself a piece of evidence that you are to consider in your jury deliberations. In every criminal case, a defendant has the right to remain silent. He or she cannot be compelled to testify by the state. Whether a defendant testifies or not is his or her choice. Should a defendant choose not to testify, you cannot hold that against them, and you are to give it no weight whatsoever. In addition to the right to remain silent, a defendant is under no obligation to do anything in his or her defense. A defendant need not make an opening statement, cross-examine the state's witnesses, call witnesses or present evidence on his or her own behalf, or make a closing argument. It is the state's burden to prove the defendant's guilt beyond a reasonable doubt. The defendant is not required to prove his or her innocence. You are here today for jury selection. In connection with that, each side may conduct what is known as the voir dire. The purpose of voir dire is to give both parties the opportunity to decide if they think you can be fair and impartial. In order to do that, each side is permitted to ask you questions bearing on whether you can be fair and impartial. This is the only time during a case when the parties are allowed to question jurors. The judge will make sure the questions asked are proper, and if they are not, you will be instructed that you need not answer. It is imperative in a criminal case that the jury's verdict be based solely on the evidence at trial. Bias or sympathy for or against a party has no role in a case. The questions asked of you will be to determine if you have potential biases or something which may affect your fairness, such as being related to a party or witness, or if you have life experiences or opinions which make it not possible for you to decide the case only on the evidence put before you. It is important that you answer the questions as fully and fairly as you can. The jury selection process will begin with the bailiff calling the names of potential jurors. You will be seated in an area designated for jury seating. Then each side may or may not ask you questions, with the state having the burden of proof going first. The parties are not allowed to argue their case in the voir dire. Its purpose is limited to determining whether you can be fair and impartial. Once the parties have asked their questions, each side has the opportunity to strike jurors from the panel by exercising challenges. Often, jury challenges are done at the bench, and if so, you should not try to determine which side may be exercising challenges or why they may be doing so. Sometimes jury challenges are done outside the presence of prospective jurors. It is very important, if you are not in the group of jurors being questioned, that you listen to the questions being asked of the others. In the event of jury challenges, replacement jurors will be seated and likely asked if they heard the questions that were asked earlier. Usually, a jury consists of 12 members and some alternates. Sometimes alternates are designated at the jury selection, and sometimes they are randomly selected before deliberations. You will be told whether the jury has designated alternates, and if so, who they are, or whether the alternates will be picked before deliberations start. If you are picked as a juror or alternate, you must not, under any circumstances, attempt to learn anything about the case outside of court, conduct any internet research, or discuss the case with anyone. You must always keep in mind that your verdict is to be based solely on the evidence provided to you at the trial. I want to spend a few minutes going over the trial process. The trial judge may begin the trial with some preliminary instructions to the jurors. After those are completed, the parties have the opportunity to give an opening statement, which is an outline of what they think the evidence will show. The state, having the burden of proof, goes first. The defendant may give an opening statement at that time, may wait until the start of his or her case to give one, or not give one at all. The state will then call whatever witnesses it wishes, with the defendant being given the opportunity to cross-examine them. Once the state has completed its case, the defendant may or may not call witnesses as he or she sees fit. with the state having the opportunity to cross-examine any defense witnesses. If the defendant does present a case, at its conclusion, the state, having the burden of proof, is given the opportunity to put on witnesses in rebuttal to those called by the defendant. As jurors, your duty is to find the facts from the evidence presented. The evidence consists of the testimony of witnesses and exhibits. As you consider the evidence, you are free to believe all of a witness's testimony, some of the testimony, or none of it. This is true even if the witness is someone who may be considered an expert, or even if their testimony is not contradicted. You, as jurors, decide what you believe and what you do not believe. Once the evidence is completed, the parties have the opportunity for closing arguments, where they each get to argue to you why they think the evidence warrants a verdict in their favor. The state, having the burden of proof, goes first. The defendant is then given the opportunity to give a closing argument if he or she chooses to do so. If the defendant gives a closing argument, then the state has the opportunity for a rebuttal closing argument. Following closing arguments, the judge will instruct you on the law, and you will be given the case for deliberation. Your verdict must be based upon the facts as you find them and the law given to you by the judge. If the state has proven the essential elements of the charge beyond a reasonable doubt, your verdict on that charge must be guilty. If, however, the state has not proven its case beyond a reasonable doubt, your verdict on that charge must be not guilty. Your verdict on any charge must be unanimous. In your deliberations on the case, you are not to consider what happens after your verdict. Under Vermont law, all matters after the verdict are solely the responsibility of the court. Lastly, there may be delays during the case, causing you to wait in the jury room. The judge will make every effort to keep those delays to a minimum. During the trial, parties may raise objections, and some of these may need to be discussed outside of your hearing. You are not to hold it against either side that they have made objections, as parties have a duty to object to questions or answers they feel are improper. You are not to draw any conclusions from rulings on objections about how the judge may view the case. Also, on occasion, witnesses are called out of order due to scheduling or other concerns. If that should occur, the judge will let you know. I hope that you have found these instructions to be helpful. Once again, on behalf of the entire Vermont judiciary, I thank you for your service as jurors.